Good day, ladies and gentlemen. Welcome to the Title VI State Complaints and Best Practices for Environmental Justice Advocacy. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session, and instructions will be given at that time. If anyone should require operator assistance, please press star then 0 on your touch-tone telephone. As a reminder, this conference call is being recorded. I would now like to turn the conference over to Brig O'Connor. You may begin.
Hi, thank you everyone for joining. My name is Brig O'Connor, and I am a staff attorney at the ACLU of Northern California. We're really excited to be hosting this, the ABA-YLD Public Education Committee, the Civil Rights and Social Justice Committee, and the Environment, Energy, and Resources Law Committee. I want to take a couple seconds to introduce our panelists today. We have Daria Neal, who is the Deputy Chief in the Federal Coordination and Compliance Section in the Civil Rights Division of the Department of Justice. And in that capacity, she works with different federal agencies to make sure that civil rights statutes are being enforced, and also that discrimination is not happening as much as possible where there is federally conducted and assisted programs and activities. Prior to that, she worked at the Lawyers Committee for Civil Rights Under Law. She also has served as adjunct professor for Howard University School of Law. So we want to welcome Daria Neal. Next, we want to welcome Caroline Farrell, who is the executive director for the Center on Race, Poverty, and the Environment in Delano, California, and also having offices in Oakland, California. The Center on Race, Poverty, and the Environment is an environmental justice organization where they conduct legal and technical assistance to help low-income and environmental justice communities in the state of California and also across the country. Caroline has also co-authored The Structural Racism, Structural Pollution, and Need for a New Paradigm in the Washington University Journal of Law and Policy, and has also conducted a ton of work within different environmental justice communities in California. And last, we have Marian Engelman Lotto, who is a senior staff attorney at Earth Justice and has also done a ton of work around environmental justice cases across the country, but is located in New York City, New York. Prior to that, she was the general counsel for New York Lawyers for Public Interest, and then also worked for NAACP Legal Defense and Educational Fund. So with that, I want to turn it over to Daria to give us a little bit of background about how complaints can work at the federal level and how that interplays with state agencies.
Okay. Great. Thank you so much, Abray. I really appreciate the opportunity to participate in the panel today. So first, I think it's helpful to kind of explain what my office does. You gave a great overview. I think specifically with regards to Title VI, we're really charged with ensuring enforcement of Title VI related to recipients of funding from the Department of Justice. Additionally, we are responsible for ensuring consistent enforcement of Title VI across the federal family. And so part of the reason why we're talking about VI today is that it's often cited as a tool for addressing environmental justice issues and challenging discriminatory practices in programs and activities that have an effect on the environment and human health. So to start, I don't know how much everyone on the call knows about Title VI and Civil Rights Act, but to be clear, Title VI prohibits discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. And so as John F. Kennedy said in 1963, simple justice requires that public funds to which all taxpayers of all races contribute not be spent in a fashion which encourages, entrenches, subsidizes, or results in racial discrimination. So Title VI itself prohibits intentional discrimination. However, most funding agencies have regulations implementing Title VI that prohibit practices that have the effect of discrimination on the basis of race, color, and national origin. So each federal agency is responsible for enforcing Title VI with respect to its own recipients. So for example, the Environmental Protection Agency provides assistance to the Texas Commission on Environmental Quality, and TCEQ operates a number of programs to enforce a variety of environmental statutes. If a community alleged that TCEQ conducted its enforcement program in a manner that intentionally discriminated against or had a discriminatory effect on a population of a particular race, color, or national origin, EPA would be responsible for investigating that complaint. It is important for me to note that claims of intentional discrimination can be brought in federal court. However, claims alleging a program or activity has a discriminatory effect can only be filed with the Civil Rights Office of the federal agency that provided the assistance. So in 2001, the Supreme Court held in the case Alexander v. Sandoval that Title VI only provided a private cause of action for intentional discrimination claims. So complainants alleging disparate impact must therefore bring those claims to the funding agency itself. So what does this mean for the work of the Department of Justice, right? Well, first, DOJ primarily funds law enforcement agencies, correctional facilities, and state court systems. And it's unlikely that we will actually have Title VI jurisdiction over any particular environmental justice matter. However, we do have, because of our responsibility to ensure consistent enforcement across the federal government with regards to Title VI, my office has had the opportunity to work closely with a number of federal agencies that provides assistance to programs that affect the environment and human health. Over the past 8 years, we've worked really hard to do just that. We've worked closely with agencies like the Environmental Protection Agency, Health and Human Services, Department of Transportation, and the Department of Homeland Security to strengthen their Title VI programs. I thought I would share a couple of examples of the work that the division has done with agencies, and then work outside of assistance to other agencies. So first, one matter I think that's important to highlight is a Department of Transportation investigation of a Title VI complaint regarding a Corpus Christi Harbour bridge project. And in that matter, the complainants alleged that this bridge project that was projected to dissect an historical African American community had a discriminatory effect against this particular community. Department of Transportation opened the matter for investigation because they were the agency that had funding, but reached out to my office to provide technical assistance as they conducted their investigation. We worked closely with DOT and invited other agencies like HUD, Department of Housing and Urban Development, as well as EPA to provide additional guidance and assistance where needed. And in the end, the Department of Transportation was able to actually reach a resolution with its recipient, the Texas Department of Transportation, to provide not only non-monetary relief for the residents who would be impacted, but also monetary compensation for those residents. So while the agency did not make a formal finding of a violation of the statute, based off of its investigation, it began negotiating a resolution with Texas Department of Transportation and was able to make a resolution that I think most people in the public were satisfied with. And that really has served as a model, I think, for what can happen when an agency really engages in an aggressive Title VI investigation and thorough investigation. So many agencies will engage in investigations, but we also have, as the Department of Justice, have opportunities to weigh in different manners. One, we often try to weigh in on legal issues through amicus briefs or statements of interest. Earlier this year, the Department of Justice filed a statement of interest in a matter called Drayton versus McIntosh County, Georgia. In that matter, the plaintiffs alleged that the defendants violated Title VI as well as the Fair Housing Act by discriminating against the plaintiffs for decades by denying or providing them unequal services such as safe water, sewer services, trash removal, paved roads, ferry service, police, fire, and emergency services that were available predominantly to whites living on the mainland in McIntosh County. The plaintiffs in this matter were members of the Gullah Geechee community. You may be aware of this community. They are descendants of West Africans who were enslaved here in the U.S., but were able to retain much of their own language and culture. So it's a very unique community and has great historical significance. So what we did as in DOJ was identified areas in which the defendants, when they moved to dismiss the complaint, had either misstated the law or misrepresented the law, and we were able to weigh in on the proper standard for evaluating Title VI claims in an intentional discrimination case, and also articulate who has standing for bringing such claims in court. So aside from statements of interest and also assisting other agencies with investigations, we also provide guidance and will issue public guidance. Just this past August, we, along with 4 other agencies, Department of Homeland Security, Health and Human Services, Housing and Urban Development, and Department of Transportation, jointly issued a guidance to state and local government agencies and other federally assisted recipients engaged in emergency preparedness, response, mitigation, and recovery activities on compliance with Title VI of the Civil Rights Act. We thought this guidance was necessary in light of many of the lessons learned in the aftermath of Hurricanes Katrina and Rita about how recipients of federal financial assistance could engage in emergency management activities in a way that does not discriminate against individuals. There's obviously a lot more that we could be doing, and I know my time is, I think, run up, but really we look for opportunities to not only educate the courts but also the legal community on the scope of Title VI coverage and our interpretation of the law. We've put out quite a few resources in recent years that are available on our website, and I know some have been provided to you as well today. So thank you. I look forward to your questions.
Thank you so much, Daria. That was really, really helpful. And if you registered for the teleconference, you have a copy of the documents that she is referencing. And so now we're going to move to Caroline to talk a little bit about the experiences that you all have had in filing complaints and some stories.
Great. Thank you very much. So the Center on Race, Poverty, and Environment was founded in 1989, and our mission is to achieve environmental justice and healthy, sustainable communities through collective action in the law. And from the very beginning, Title VI was an important tool that we used, both in terms of representing communities that we worked with directly in the San Joaquin Valley of California, but also throughout the country. But it was also a tool that our founder, Luke Cole, trained a lot of legal services lawyers to engage in this practice as well in order to build up kind of the legal practice of environmental justice using Title VI, because it can be a very important tool. And it really gets at, I think, 2 maxims that guide our work a lot with low-income communities and communities of color. The first is the cornerstone EJ principle that communities speak for themselves. And the other is that lawyers should be on tap, not on top, meaning that lawyers should really be taking the lead from the community in terms of devising strategy, identifying goals, really using these opportunities to build community power. And we saw Title VI as having an important role in building community power for 3 main reasons. It allows the community to tell their story. And we use the Title VI worksheet that is included in your materials as a way of kind of guiding the conversation. And lawyers are helpful in terms of like making sure that the story kind of aligns with the requirements of Title VI, but it's really kind of open and broad and able for the community to sort of put their analysis and their lived experience into the complaint, which is really important. The third, or the second reason why it's such a valuable tool is that it allows communities to document the racially disproportionate impact that environmental policy has. Everything from enforcement to funding to permit requirements to siting. It allows communities to raise up what is often not considered, which is how environmental policy that applies to all of us affects different people in different ways depending on the context in which they live. And every study has documented that people of color are more exposed to pollution than white people. And that's just, I mean, race is the driving factor of a lot of these disproportionate impacts, and it allows us to call that out in a very intentional way. And the third reason why I think federal level complaints are very important is it allows us to look at patterns across the state. It allows us in many ways to look at data at a national level and how environmental policy and civil rights are impacted throughout the country, allows us to identify patterns and practices. And with Clinton's executive order, creating a federal interagency working group on environmental justice comprised of heads of the federal agencies, it allows a focus to be placed on how to create consistent practices throughout the country, recognizing that there are some significant differences in how different regions of the country value and enforce Title VI and civil rights generally, as we're seeing more and more since the recent election. And I will talk briefly about a case study. There's some materials in your packets around a complaint we filed in 1999 around Angelita C., which involved the proximity of Latino school children and where their schools are located vis-a-vis the application of a fumigant methyl bromide, which is often used in strawberries, carrots, sort of other agricultural products. And we alleged in the complaint that Latino school children were disproportionately impacted by exposure to methyl bromide at school. And that complaint was filed in 1999, and in Title VI and the regulations, there are various timelines by which complaints need to be processed. And this complaint was processed over the course of 12 years, which exceeds that statutory timeline. And the report that we issued that sort of talks a little bit about the case and how it sort of got developed and how EPA made its final determination is also in the materials for a little bit more background. But just to give a little bit on this, and I know my time is almost up, is to say that this case represented the first time EPA had made a preliminary finding that there was a disproportionate impact to Latino school children. They set about then working with Department of Pesticide Regulation, which was the agency that we were challenging their regulation of pesticides. That's the state agency that received federal funding from EPA, so therefore they were the kind of responding party for the complaint. So they made the preliminary finding that there was a disproportionate impact. But then they set about to resolve that finding directly with Department of Pesticide Regulation. They did not include the community in resolving that complaint. And the remedy was increased monitoring of methyl bromide, which has been phased out and replaced with something else over the 12 years that the complaint was processed. And in parental education about fumigant and pesticide use, neither of which stopped the disproportionate impact, and neither of which acknowledged that methyl bromide had been replaced and used and other pesticides had come in that were also disproportionately impacting students. And I think the report kind of tracks all of the various decisions EPA made. We did a FOIA request, a Freedom of Information Act request, and reviewed all the documents related to the investigation. And that was a fight to get those. But the documents that we did get painted this picture that EPA made various decisions along the way to minimize what the issues were that the complaint was bringing up. And it also demonstrated that the Office of Pesticide Regulation played a big role in crafting what the outcome was. The Office of Pesticide Regulation wanted to make sure, within EPA, wanted to make sure that nothing in the decision implicated that their rules were deficient. So they did not want a finding that their rules somehow caused a disproportionate impact. And that led the way towards the outcome, which kind of shows that, you know, if you're going to allow the substance of environmental law to overshadow and sort of trump the civil rights aspect of environmental law, you're never going to find an outcome that is suitable for the community. And so I think this track of not including residents and then finding and trying to minimize the impact of your findings is going to have a negative impact on resolving some of these persistent issues. But it's an important tool, and it definitely, I think, brings to light, one, you know, community perseverance, the need for community involvement to get meaningful resolutions, and it also demonstrates how agencies' choices do have concrete, real-world civil rights implications, and I think those are really valuable things for us to think about moving forward and how we conduct our Title VI advocacy.
Thank you so much for that, Caroline. A really powerful story and really kind of helps to ground this work in a tangible way. Marion, I know that you also are going to be able to give us some context for some of the work that Earth Justice has done around Title VI and other state complaints. Marion?
She might be on mute.
Can you hear me?
Yeah.
Okay.
Yes.
Thanks so much, and I'm really thrilled to be part of this. Before jumping into some of the work, I just wanted to mention, to add to the great description that Daria gave of Title VI, that part of you can bring a claim in court of intentional discrimination, as Daria mentioned, can raise a claim under the regulations at each agency for discrimination in the form of unjustified disproportionate impact on the basis of race, color, or national origin. And one of the forms that discrimination can take is not providing services that are linguistically appropriate or accessible to someone who speaks languages other than English. And there are really good guidance documents on discrimination in the form of not providing services to people who are called limited English proficient. And I just want to mention that because I think that is an issue. It's an issue. The barriers to participation for people who speak languages other than English as their primary language is a really key issue in terms of the ability for folks to participate, and that also comes under Title VI. But taking a step back, I have, as Abray said, I have a civil rights background, and I landed at Earth Justice about 7 years ago. Earth Justice works on a range of environmental issues. It's a nationwide organization. We have offices all across the country, and we do work on energy and climate issues and really important work on oceans and wildlife and endangered species. And then we have where I kind of inhabit space in what we call healthy communities, and that's work on water quality and air quality and the disproportionate impact of contamination on vulnerable communities and communities of color and environmental justice communities. And I've brought, in the last couple of years, more focus at Earth Justice to civil rights enforcement in the environmental context. And we've been doing a lot of work with Center for Race, Poverty, and the Environment and groups all across the country in trying to move civil rights enforcement in this context. I should also mention that I'm actually going to Yale in a couple weeks and starting an environmental justice clinic, so you can find me there. But I think what's notable is Caroline's point that Angelita C. in the Obama administration was the first time EPA ever made a preliminary finding of discrimination. EPA has been around since the 1970s, and it has never withheld federal funds because a recipient of federal funds has discriminated. It has only once made a preliminary finding of discrimination. And what that reflects is that civil rights is largely unenforced in the environmental context, at least among recipients of federal funds from EPA. And so there are groups all across the country, including Center for Race, Poverty, and the Environment, which has toiled in this field for a very long time, and community groups in EJ communities that have filed complaints in the 80s and the 90s, in Flint, Michigan, and in Tennessee, and in Texas, and in Alabama, that have been waiting for justice. And every day, recipients of federal funds make decisions to put another facility, to permit another facility in a community of color, or to allow an expansion of a refinery in Beaumont, Texas, where already those refineries have made neighborhoods nearby almost unlivable. And yet these decisions, there's just no accountability for these decisions. So in the last 5-6 years, communities have come together in alliance, and Earth Justice has really been honored to be a part of that. And I want to just share a little bit of what we've been doing and highlight one particular case. So all of us together have been pushing EPA to create what they say they want to do, a model civil rights enforcement program. They are so far away from a model civil rights enforcement program. We need to at least have a functional and effective civil rights enforcement, and then we can move toward a model. They need a guidance document that has clear standards. They need to make findings of discrimination so where it's appropriate, so recipients of federal funds will know that they're serious about enforcing the law. If you think about employment discrimination, we would never say, gee, it's okay that nobody's enforcing employment discrimination law. We expect that to happen, and in the environmental context, it just has never happened. So it's a whole culture shift, and so we've been working on that together, commenting on rulemaking, which we could go into later, policy ideas, trying to push for a guidance document, trying to push for some decisions. At Earth Justice, we have some litigation on behalf of the communities with some of the oldest complaints that are pending, including one from Flint, Michigan that was filed in 1993. And, I only think about if EPA had paid attention to the St. Francis Prayer Center's complaint in 1993 and how things might have been different if Michigan felt that they actually had to pay attention to civil rights in this context. And we've also been working with communities on administrative cases filed with EPA that claim that there's either a failure to take account of a potential impact, a failure to even analyze whether they're complying with the law, or actually taking action that has disparate impact. And there are really two reasons to work on these cases. One is that people deserve justice. It's unacceptable that civil rights is unenforced in this context, and people have the right to raise issues of discrimination and to have them addressed. And the second is by following these cases, as CRPE and Earth Justice and others have done, we're able to know what's happening and advocate for change at EPA. The one case I wanted to just lift up is I have the honor of representing residents in Uniontown, Alabama, who live near Arrowhead Landfill, which is the largest landfill in the state of Alabama. It's permitted to accept 15,000 tons of waste a day and actually takes waste from the entire eastern seaboard, 33 states. And it sits directly across a road from where people live, from people's homes, feet away from people's homes. The stench is horrible. And the facility was permitted for construction and operation despite the fact that it's right next to, it's adjacent to a historically black cemetery. So when you visit the cemetery, the smell of the landfill is overwhelming. The town has approximately 2,000 residents, and they're asked, actually not asked, they're just subjected to waste from the 33 states. Then in 2008, more than 300 miles away, you may remember that coal ash breached an impoundment in Kingston, Tennessee, sending millions of tons of this toxic brew of coal ash through a middle-class white community. It was the largest coal ash disaster the country had ever seen, and the area was declared a Superfund site. Homes were totally destroyed. And after a year, there was a clamor to get rid of this coal ash. So where do you put it? It was moved by the Tennessee Valley Authority, with EPA's approval actually, across state lines more than 300 miles away to this municipal solid waste facility in this little town of Uniontown across from people's homes. And as they say in Uniontown, when it was boarded on the trains in Tennessee, it was considered hazardous waste under the Superfund law. But when it came to Uniontown, which is 90% black and has a per capita income between $8,000 and $9,000, it fell under the law governing waste facilities, which is called RCRA, and was no longer considered hazardous. So nobody wore hazmat suits. Nobody was given a hazmat suit. And there were no protections for community members, such as water monitoring at their homes or air monitoring in the community. Protections were grossly inadequate, and this affects people's lives. People feel that they have more health problems than they did before, which is something we could talk more about. And this, unfortunately, follows a well-documented pattern across the country where communities of color are, as Caroline said, disproportionately burdened by waste and toxic sources. And study after study show that race is the strongest explanatory factor for the location of such environmental burdens. Civil rights, again, have been largely unenforced. We are representing the community. The complaint was filed at EPA. EPA is doing an investigation, and it's totally unacceptable to wait and wait and wait. In theory, there's 180 days between the time EPA accepts a complaint and finishes an investigation. Frankly, we're less concerned about whether it's 180 versus 190 days and more concerned that they do a timely and thorough investigation, and this is the kind of case where they should make a finding of discrimination, but we're waiting.
Thank you so much for that. And so we're going to actually move into a moderated Q&A, and then after that we'll move into audience Q&A. We have learned a lot about Title VI and how that, plays out in different agencies and how that can look for different organizations and attorneys who are filing these complaints. And so one thing that seems like a recurring theme in discussing how to file these complaints and what's going to be helpful is that civil rights is not necessarily, it's not enforced fairly in the EJ context. And so, Caroline, I know that you all provided the Title VI complaint form, and Marion, you also discussed, different ways that you all have utilized different federal complaints and state complaints. What are some tips that attorneys who are listening to this can consider to get the best answers, and also ways that you can help build capacity in communities, because it also sounds like that's a critical part of this, is making sure that community voice is really at the forefront of these complaints.
Caroline, do you want to start?
Sure. I'll start. I think that, so the first is, we typically work with communities and residents who have been engaged with their state agencies for a while. So the Title VI complaint is often part of it's one piece of a larger strategy. And I think that's really important because, as Marion was saying, we're waiting for enforcement to actually happen. So having it as a piece of a strategy, I think, is really important. Working with the community, as I said, to sort of document the violations and to tell the story. I think releasing the complaint as part of a media strategy is really important, whether it's a press conference, whether it's sometimes we've actually gone to Sacramento because we're filing usually against either a county or a state agency, and we will go and deliver the Title VI complaint to the agency and maybe have a press conference outside. Things to really highlight the fact that this is happening, that there is some accountability, or the community is expecting some accountability. We also format it as if it were a court filing, if only to psychologically give the impression that this is a formal complaint, that we expect a formal process. That isn't always what happens, but in terms of the community knowing that they have the right to ask for this and to demand it, basically, and that there's an obligation on the part of the federal agency to review it. So those are a few things that we do to make sure that the filing of the complaint has some immediate impact and some attention, where the community is able to tell their story, not just to the agency that we're filing with, but also to the larger community. And in doing that, it keeps the issue at the forefront. So it took 12 years for Angelita C. to come to resolution, and even though that was an unhelpful resolution, it certainly has motivated the community. And throughout this time, the state of California has been looking at the impact of schools near fields where pesticides are applied. And just a couple of years ago, the California Department of Public Health released a report that documents the disproportionate impact of pesticides on Latino school children. And as a result, now the Department of Pesticide Regulation is proposing regulations to address that issue. We feel that those regulations don't go as far as needed, but we are seeing movement on the issue, and it's because the community is telling their story in a variety of venues and pushing the issue as part of a larger campaign.
I'll build on that. This is Marion, with hopefully 3 quick points. One is, at the get-go, when considering bringing a civil rights complaint, it's important to have a conversation about, and this is a community-based conversation, the affected community should be thinking about what is the goal? How does a Title VI complaint fit into what the community wants to accomplish? And I think it's important to be very honest that quite often these cases, when filed with EPA, do take a long time. The Department of Education, by contrast, processes many, many more cases and gets through them, and they resolve quite a number of cases each year. There is not that record in the environmental context, and so we have to be realistic. And so say, what are we trying to accomplish? And it could be that this is an important piece of the puzzle. There may be other legal avenues as well, or other non-legal avenues, communication pieces, organizing pieces. So thinking about the Title VI complaint in the context of an overall campaign or strategy, as Caroline was talking about, I think is really important in evaluating those various options. As an example, I represent a group called the Ashford Spa Community Organization, which also has one of the oldest complaints in the country. This is in Tallahassee, Alabama, and they have really historic historic property, it's Black-owned property, and there's this Stone Store landfill right in the middle that's devaluing their property and affecting their lives. And they are now organizing, in addition to having this complaint at EPA and trying to push EPA to make a finding of discrimination, they have commented on the latest permit proposal. They have turned out at permit meetings. The recent hearing had something like 150 or 200 people in a community that only has, a few hundred people. So organizing, educating, bringing things to light, that's part of their strategy. Second, I think it's important to think about what kind of record of discrimination you have. I mean, I think about, again, going back to Flint, people coming to meetings with bottles of dirty water and essentially being dismissed, not being taken seriously, and that's not acceptable. And I think communities around the country really feel very frustrated because they have this experience and they're not paid attention to by the government that's supposed to be accountable to them. So how do you develop that record? And there is now a lot of community-based science and we should be thinking about ways to help communities get data and get information into their hands so that they can advocate and put some of this data out there. So thinking about the science piece of the environmental justice advocacy is an important part of these cases. In theory, you file a complaint and it's the agency that should do an investigation, but in fact at EPA, because they're still building their skills, because they don't have the record of competence in this area, we know that their investigations have not been effective. So really being tooled up to figure out how to have an effective presentation. And finally, I think it's important to advocate with the agencies. Recently in a case I have in North Carolina, about 20 community members came to EPA and presented to them, asked for a meeting to really get across how, in this case, it's the permitting of more than 2,000 swine facilities where these swine facilities have open cesspools of manure near people's homes, and the manure is sprayed over spray fields, and literally people have manure in the air as in a form of mist, and it affects their lives, it affects their health and their enjoyment of property, et cetera. And they came to EPA. The investigation was taking a while, and EPA had not come down to do a site visit, and they said, well, if EPA is not coming down to us, we're coming to them. And I think it's important, you don't just file the complaint and then say, oh, it's in someone else's hands. It should be part of a larger strategy, including advocating with the agencies to actually get things done.
Wow, that's really powerful, and thank you all for sharing that. I'm going to ask one more kind of broader question, and then we'll move to the audience Q&A. But this is, kind of building off of those points that were just made. What are some tools that you all and Daria, you might want to chime in right here as well, that you all feel like are in place, especially considering that we're going to have a new administration soon. What are things that people can be thinking about? And then also, are there benefits to potentially thinking about filing more than one complaint with different agencies to make sure that there is the most effective resolution in the end?
Yeah, so this is Daria. So on your last point, yes, I think if you can file with multiple agencies, then you should. I'm blanking at the moment. There's a recent complaint that was filed by Marion Shop, that actually several, where the issue involved a recipient or several recipients of funding from different agencies, so Environmental Protection Agency and Department of Transportation. And so the complaint was filed with both of those agencies. And so what you do, I think, in that circumstance is you're really forcing those two agencies to come together, and one in which one may have a stronger program than the other, can potentially lead to a more robust investigation going forward. So I think that is really important. I think it adds additional leverage. The challenge, I think, is that you have two different agencies with who may have different policy perspectives on Title VI enforcement, and that can potentially create a clash. But our goal, part of the Civil Rights Division, is to try to prevent that from happening with our responsibility to coordinate and ensure consistent enforcement. And so I would say if folks consider filing complaints with multiple agencies, that they also copy the Civil Rights Division's Federal Coordination and Compliance section as well, and we can try and facilitate a coordinated effort among those agencies. To your first point about different tools, and I'm sure Marian and Carolyn have comments to make on that. I do want to emphasize to folks on the phone that federal agencies, civil rights offices have issued a range of documents and guidance over the past 8 years. Guidance in the form of Dear Colleague letters, joint guidances with other agencies, notices, frequently asked questions, and many have posted them on their website. I strongly encourage you to go on their website and pull down that information. Save it so that you can use it for future reference or create your own library of information, because that can be really important going forward. And we know web pages get updated all the time. So to really make sure that you have what the government has put out over the past few years, I think it's really important to go online and see what we've done and to save that for yourself for future use and future advocacy.
I'll just add, I know the title of this webinar included whether we go to the states, and so I wanted to address that piece of your question. So anytime you think about a Title VI complaint, it starts with, is there a recipient of federal funds? And one way to evaluate whether a private or public agency receives federal funds is to go to usaspending.gov and say, is this hospital, is this